director. Company law establishes clear boundaries between a legal entity and its participants. However, these boundaries become particularly significant when analyzing contractual obligations entered into before a company is officially registered. At the heart of this study is the legal status of so-called pre-incorporation contracts made on behalf of a future company and the associated liability of its founders or promoters. The case in question involves a sale and purchase agreement entered into by four friends on behalf of a yet-to-be-formed company, Potrix Ltd, which was later incorporated, but unfortunately went bankrupt without fulfilling its obligations to the seller, Jessie. This essay examines who bears liability under such a contract, the founders themselves or the company after incorporation. It also considers how the legal situation would change if the company had never been registered, as well as the impact of entering into a novation agreement under which obligations can be officially transferred from the founders to the company. The applicable legal provisions include, foremost, Section 51 of the Companies Act 2006, which governs the liability of individuals acting on behalf of unregistered companies. The analysis also draws upon key case law, including Kellner v. Baxter from 1866, which addressed the consequences of entering into contracts prior to incorporation, and Novello v. Morrison from 1839, which concerns the legal nature and consequences of novation. These rules and precedents allow for a comprehensive assessment of Jessie's legal position and help determine whether he may seek compensation for his losses. At the time the contract was entered into, Potrix Ltd had not yet been incorporated and therefore did not exist as a legal entity. This is a crucial legal point because only legally recognized entities can be parties to contracts and bear contractual obligations. In English law, a company acquires legal personality only upon registration under the Companies Act 2006. Before incorporation, a proposed company has no legal status and no capacity to enter into enforceable agreements. According to Section 51 of the Companies Act 2006, where a person enters into a contract purporting to be made by or on behalf of a company before it has been formed, that person is personally liable on the contract unless the contract specifically provides otherwise. This statutory provision protects third parties, such as Jessie in this case, who contract in good faith with representatives of a non-existent entity. The rationale is to ensure that those acting on behalf of such a company cannot escape liability simply because the entity does not yet exist. This principle was firmly established in the case of Kellner v. Baxter in 1866, where the court held that a contract made in the name of a company not yet in existence cannot bind the company, nor can the company be retrospectively bound by it upon incorporation. In Kellner, the court emphasized that a company cannot become a party to a contract that it was legally incapable of entering at the time it was made. Therefore, the individuals who signed the contract were held personally liable. This precedent continues to influence English company law and has been cited in subsequent judgments and legal scholarship. The issue becomes particularly important in commercial practice, as founders or promoters often negotiate and agree on contracts before incorporation, such as contracts for purchasing property, leasing office space, or hiring employees. Unless these individuals take appropriate legal steps, they will be personally liable for those agreements. Even if the company is later registered and adopts the contract, a process sometimes referred to as ratification, this does not relieve the founders of their personal liability. In English law, ratification requires that the principal, in this case the company, had legal capacity at the time the contract was made. Since the company did not exist at that time, ratification is legally impossible. This distinction is important. While a company may choose to enter into a new contract with similar terms once incorporated, this would be a separate agreement, and it would not eliminate the original personal obligations of the promoters unless a novation occurs, as discussed in Section C. Thus, in the absence of express provisions in the pre-incorporation contract that exclude promoter liability, and without a subsequent novation, the legal position is clear. The individuals who signed the contract on behalf of Potrix Ltd are personally liable. Jessie, therefore, has a valid legal claim against the founders for breach of contract when the company failed to perform its obligations. So, would the answer change if Potrix Ltd had never been registered? Yes, actually, the legal position would be even clearer in that case. If the company had never been registered, it would not exist in law and, well, it simply could neither enter into nor ratify the contract. The full liability would remain with the founders who signed the agreement. Under Section 51 of the Companies Act 2006, such individuals are liable because they acted on behalf of a non-existent entity. The court in Kellner v. Baxter confirmed that in the absence of registration, obligations cannot be transferred to a company. Academic literature also emphasizes that without registration, neither ratification nor novation is possible. Therefore, in the absence of a legally registered company, Jessie has the right to seek performance of the contract solely from the individuals who signed it. Now, what if the parties signed a novation agreement? If, after the company's incorporation, the parties entered into a novation agreement under which Potrix Ltd becomes a party to the contract instead of the founders, then the obligation is transferred to the company. In this case, the founders are released from liability. Novation, you see, entails the termination of the original contract and its replacement with a new one, involving at least one new party. This is quite different from ratification, which does not change liability under a pre-incorporation contract. In Novello v. Morrison, the court held that novation requires the clearly expressed consent of all parties. Where proper novation has occurred and the company later goes bankrupt, Jessie cannot bring claims against the founders as they are no longer parties to the obligation. So, to sum things up, when a contract is concluded before a company is registered, the founders are personally liable unless a proper novation occurs. Ratification by the company itself does not release them from liability. If the company was never incorporated, full liability remains with the signatories. Only through novation can liability be transferred to the company, relieving the founders of responsibility.